Good morning. May it please the court.
Hold on, please.
I'm sorry.
We want to get you on tape here.
All right.
All right, let's proceed.
Thank
Good
you.
morning.
I'm Attorney Kenneth Quad. I'm here with co-counsel Elliot Barrison, and together we represent Diane Golchin, the plaintiff in this case, and the appellant. This case involves a claim for benefits under the MedPay provisions of Liberty Mutual's automobile insurance policy. The plaintiff made a claim for these benefits as a result of an auto accident which she sustained and in which she suffered serious injuries. Liberty Mutual denied the claim on the basis that the expenses resulting from the plaintiff's medical treatment had been satisfied by her health insurer, claiming the basis for that position was that MedPay could not duplicate those expenses, and that resulted in a first round of appeals, which this court decided in 2011. On remand, Liberty's position changed. It filed a motion for judgment on the pleadings, in which it essentially argued that no medical expenses are incurred unless the plaintiff is billed for those expenses directly by her providers. Despite the clear policy language, which I'll read. Under this part, we will pay reasonable expenses for necessary medical and funeral services incurred as a result of an accident. We will pay for expenses resulting from bodily injuries to anyone occupying your auto at the time of the accident. The language does not specify who must incur the medical expenses or when the expenses are billed or must be paid for, or in fact, who must ultimately pay the bill. To circumscribe the policy language as narrowly as Liberty Mutual is suggesting here is a complete rewriting of the policy. Essentially, the only way that Liberty Mutual can prevail here is if the court accepts the proposition that, because it's undisputed that medical expenses resulted from the accident, which again is all that the policy requires.
And it's undisputed that there was a lien that was paid.
And there was a lien that was paid. But Liberty's approach is even narrower than that. It boils down to the proposition that unless the plaintiff is actually billed directly by the providers as opposed to through a lien from the insurer subsequently, then MedPay does not apply.
Is it your view that the expenses are potentially borne by the plaintiff because of the possibility of a lien, or only upon the placement of a lien?
Well, Your Honor, keep in mind that this is not an indemnity policy. It doesn't speak to actual losses. It only speaks to expenses. So as long as the expenses result, and there's no dispute here that they have resulted, and I would refer the court to the initial round of appeal and not only Liberty's position in that appeal, but the court's statements and its opinion that medical expenses resulted. The lien, we should not even reach the issue of the lien. But of course here we have that also, and it's not insignificant because many drivers in this state purchased MedPay for the specific contingency that occurred here, which is the assertion of a lien against a third-party tort claim.
Well, does the word, I mean, does the existence of a lien inform the definition of incurred?
I don't believe it informs the definition, Your Honor. I think what informs the definition is the second sentence of the paragraph in the policy, which is pretty as clear as it could possibly be, I would submit. We will pay for expenses resulting. It follows immediately after the word incurred, the first sentence which includes the word incurred, and then the policy goes on to say that we will pay as long as expenses result. So I would submit that that's what qualifies the term incurred.
I understand the language, but if you, what if you didn't have a lien and the entire bill was paid by Blue Cross Blue Shield, what would be the purpose of paying this to your client?
Well-
Because she had paid it's a very small piece of the premium on MedPay, isn't it?
I really can't say how small it is.
Okay.
But I don't think we'd be in this case. I don't think the case would have been brought. My client would have been whole. But if you're asking hypothetically, would she have theoretically had the right to still bring the
I
case?
take it you would say yes, she would.
I would say yes, absolutely.
And I'm trying to figure out what would be the policy behind that sort of double recovery? Just because that's what the contract says? I mean, maybe that's it.
Well, it's what the contract says. The contract does not exclude the circumstances present here from coverage. I guess the public policy is best left to the legislature on that. I don't know.
Or the insurance commission.
The public policy is enforcement of contracts.
Yeah, okay.
But speaking again to the point of whether the circumstances here not being excluded, specifically excluded by the policy does go on to list a number of scenarios where MedPay will not be
Well,
triggered.
could you just explain, kind of a background question for me? Did the plaintiff actually pay for the medical expenses?
She did when she paid the lien. Well, she paid in two ways. First of all, she bought her health insurance policy and paid for that. She paid her MedPay premiums, and then she paid back Blue Cross Blue Shield $32,000, and which was in Blue Cross Blue Shield's view the value of the services rendered. So I would submit, Your Honor, that she did in fact pay them.
All right.
Did Blue Cross Blue Shield have to pay these bills?
That's a good question. It's a good question because we don't know if there was a deferral provision in the health insurance policy, and there I'm talking about the situation where a health insurer is allowed
It's the Metropolitan case.
that's Metropolitan to defer to MedPay.
I thought in your brief you argued that there was a deferral.
No,
You
I
just-
don't believe so. I don't think we've gotten any information on that.
It seems strange because the insurer and the health insurer in Metropolitan was Blue Cross Blue Shield, so.
Right, but if there was a deferral provision, there would be a good reason why the health insurer would not defer to MedPay. The providers get quick payment. The insurer gets the benefit of the contracted rates with its providers, and then, of course, where there is a third-party liability claim, they know they're going to get reimbursed a good chunk or all of the value of what they paid. So there are good reasons for not. That's why the deferral language that was at issue in Metropolitan is an option. It's an optional. It's an option for the health insurer. It's not mandatory, and there are good reasons why they don't exercise it. In the Allstate versus Beers case, which wasn't exactly this scenario, but it did involve a situation where MedPay was duplicating other coverage. In that case, it was underinsured coverage. This court made very clear that if the circumstances under which MedPay would not be triggered are not specifically listed in the policy, then other circumstances, such as the one we have here, are excluded by implication. And one of the cases from the other jurisdictions that I cited in my brief makes the same point. That's the Samsel case. And that's Samsel versus Allstate. It's from the Arizona Supreme Court. And in that case, the court said, if Allstate had intended to limit, the injured person's name was Lisa, had intended to limit Lisa's coverage to expenses for which she had actually become directly legally liable, or even those she had actually paid, it could have so stated in the policy and made it clear.
But this policy, of course, is promulgated by the commissioner.
Well, it is, but keep in mind that MedPay itself is not either mandated by statute or regulated by statute.
Right, but it is in the, but the language of
The
is written by the commissioner.
That's correct. That's correct. And again, there is no exclusionary language whatsoever in the MedPay section of the policy, or even in the general exclusions of the policy, which even suggest that MedPay would not be applicable simply because the injured person was not directly billed by her providers. I would also submit to the court that, with one minor exception, all of the state courts, including many at the highest appellate level, that have reached this question in other jurisdictions, have adopted the position that we are urging the court to adopt here.
Did you say one exception?
Pardon me?
Did you say with one exception or without one?
Yeah, there was one exception that the motion judge noted and that I mentioned in footnote 3 to my brief, which is the Carbona versus Standard Security Life 1965 case out of New York State. I would also point out to the court that with respect to public policy, MedPay helps control healthcare costs. Why? Because, again, providers are paid at the contracted rates which health insurers arrange, and which are significantly less than fair market value, as we see in this case, where fair market value was over $100,000 and the health care lien which resulted was $32,000. And then the health insurers in auto cases have the option, depending on whether or not proceeds are recovered in a liability claim, of being reimbursed for some or all of those outlays. So with respect to the health insurance crisis, or health, whatever you want to call it, healthcare economics, MedPay serves an important public policy goal, and it's one which Liberty's position
But
here would completely
does
eviscerate.
it serve that goal in the context of a case? And I know that's not this case, because there was a medical lien here which was collected upon.
Right.
But does it serve that goal when, in fact, the injured party pays nothing for health insurance?
Well, it serves another goal. It serves the goal of the injured party being either fully compensated or as close to being fully compensated for his or her injuries.
But this is intended to pay for the health care costs
Right, which
growing out of those injuries.
Which-
And if those are already paid for in their entirety by another insurance policy, what purpose?
That's one situation, Your Honor, but here we have the second act in the drama, which was the assertion of the lien.
Well, I agree.
Right.
This makes it, to me, a different case.
Right,
But, okay.
right. So,
Well, let me ask you pragmatically. If we were to say that payment is entitled only upon either the placement of a lien or the payment of a lien, what consequence would that have pragmatically on the way this works?
I suspect very little, but I can't say for sure that it would have no impact. I really have nothing to base that on. I am not primarily a personal injury attorney, so I don't have a breadth of experience to draw on, Your Honor. Just in closing, point out to the court that as the court recognized in its prior decision, MedPay is optional primary insurance. It covers the same risks as, once PIP is exhausted, it covers the same risks as health insurance. It's not primary insurance, it's optional insurance that Ms. Golchin paid for, and we would ask the court to reverse the motion judge's decision.
Thank you.
Thank you very much.
Good morning, Your Honors. May it please the Court, my name is Miles McDonough. With me as my colleague is Christopher Riley. We represent Liberty Mutual, and we seek affirmance of the judgment below. Your
So
Honor,
what have I purchased here? I purchased this policy. I'm in the same position as the plaintiff here. What have I bought?
you have bought a wonderful product that dovetails with health insurance. Just like we're told by the legislature in the universal health legislation in April of 2006, there is a flat-out carve-out for MedPay. MedPay is defined to not include, health benefit plan under universal health is specifically defined to not include MedPay and specifically defined to include Chapter 176 Blue Cross health insurance.
You're going to have to slow down and explain
I'm sorry,
that to me.
Ron.
I still don't know what I purchased here.
You have purchased coverage which applies to copays, deductibles, out-of-network service care that you get. So it is a very important product, and so important that the legislature insists that it be offered. It's not mandatory coverage, but there's a mandatory offer component to it.
So I am, go ahead. There you go. So I am injured, and my health care provider, I do have a few deductibles and whatnot, but, you know, they're modest. My health care provides the coverage. I then file a suit. The policy of the other driver is surrendered. It's $100,000, and the health care insurer says, okay, fine, that's great. We're now going to take $30,000 of your money for us. Why shouldn't the MedPay fill that gap?
Because
they've taken the money from me.
Three reasons, Your Honor. One, the Wiggins doctrine that hasn't even been addressed, and the court asked to be examined on remand, hasn't even been addressed by the plaintiff. Two, the statutory matrix that specifically applies to this issue here that I'd like to address. And three, as a matter of deference, the Commissioner's Bulletin deals with this specific issue here, and it's not a statute. It does not have the force and effect of law, but as a matter of deference under the Morin case.
Commissioner's Bulletin mentioned liens?
Mention what, Your Honor? I'm sorry?
Liens?
Liens?
Yeah.
I'm not sure if it's referenced. I don't know that it expressly does in paragraph 4, Your Honor, but that's what I'm referring to. The Commissioner's Bulletin expressly says that there is one and only one exception where from $2,000 above, the health insurer will not pay. That exception, one exception, not two, is if the health insurer denies coverage. The Commissioner, retired Judge Burns, did not say that we're going to have another exception, which will kick into effect for some unexplained reason after PIP runs out at $8,000.
Isn't this the same bulletin that was addressed in the first Golchin opinion?
Yes, in part, Your Honor, yes. The court has never ultimately answered the question. The court said we may be right in our reading of that document, and I'm saying we are right. The language is plain. And Commissioner Burns did not have the second exclusion to the duty of health insurance to keep paying that the plaintiff somehow suggests that they did.
So if I'm a consumer deciding whether to buy MedPay, I read the policy language, which makes no reference that says we will pay you only for copays and out-of-network, says nothing about that. I'm supposed to be reading the Commissioner's bulletins to understand that this policy provides far less coverage than it sounds?
Well, no, Your Honor, if you're reading the policy, you're also reading on the front page that it incorporates every motor vehicle insurance statute in the Commonwealth. So obviously they're not.
And as a consumer, I'm expected to read all of them?
No, I don't know that you are
So,
expected
I'm
to do that.
reading the language. Under this part, we'll pay reasonable expenses for necessary medical and funeral expenses incurred. It does not say we will pay only those reasonable expenses not covered by your health insurance. It could have said that.
It says incurred expense, Your Honor. That's one point. The other point is going back quickly to the
Well,
statute.
the expense was incurred, doesn't say expense incurred and paid by you.
I'm sorry, MedPay?
Under this part, we will pay reasonable expenses for necessary medical and funeral expenses incurred as a result of an accident. Doesn't say incurred by you. Doesn't say incurred and paid by you.
All right, then you're okay. Incurred by anybody it doesn't matter who incurs it with regard to the common law bar. In Wiggins, the common law bar applies regardless of who incurred what. If it's an indemnity policy, which I'd like to address, and it is, then the common law, that's why it's a common law bar. It applies even though you have two policies that might, at first glance, have been made out to apply. Now, it doesn't for other reasons that I hope to get to. But the common law bar under Wiggins and reaffirmed under Mailhot 140-some-odd years later precludes coverage here as a matter of prevention of double payments under indemnity policies. Now, this policy is an indemnity policy. Williston says it. The court observed that already. In addition to Williston, the Kimball article goes through all the cases and says it's MedPay is an indemnity policy. The Appleman treatise at section 4902, we quote part of that section or subsection or subparagraph in it in the brief, but the very first paragraph in section 4902 in Appleman, Your Honor, says that MedPay is an indemnity policy, and it is because it has that essential quality of an indemnity policy.
But I mean, it's one thing to say it's in the small print.
I'm sorry?
It's one thing to say, no, you're not covered because you didn't look at the small print. It's not even in the small print. How, I mean, in order to understand your position as a consumer deciding whether to buy MedPay, I would have to be a scholar in the law of insurance. Why is that not basically just consumer fraud? If you wanted to do this, then tell the consumer what they're buying.
Your Honor, first, in terms of construing the policy, this court held in Given that the statutes control. This court looks to the statutes and sees what they say in order to interpret the statute. One cannot look at the universal health legislation and conclude that MedPay was intended to double up on health insurance. It's impossible. It's an express carve-out. One cannot look at Chapter 176.0 and the regulations under it and come to the conclusion that MedPay was intended to double up on health insurance. Again, it's impossible because they're mutually exclusive as to the portions of the bills that they cover.
They are not. What is mutually exclusive between MedPay and 176.0?
Between MedPay and health insurance, Your Honor. 176.0 in its regulations say it's illegal to bill the patient.
Yes, for the health provider to bill for the patient for things that are covered by insurance. What does that have to do with MedPay?
Because of the way that they all work together, Your Honor. Under 176.0 in the regulations, it's illegal to charge.
But it's not illegal,
It's illegal for
to
Blue
register a
Cross.
lien. It's not illegal to impose a lien for the
Oh,
money
but you're
that was paid.
equating, we don't equate a lien with incurring an expense, Your Honor. I heard that argument from the plaintiff.
You're saying that.
Right.
You say we. We decide.
No,
whether-
I understand, Your Honor. I'm saying we, in terms of our position in the cases, we don't buy into the plaintiff's argument on that score by any stretch. And it is for three reasons. The common law bar should apply. It is an indemnity policy. Number two.
We have consistently said that it's a primary insurance policy.
Your Honor, I'm talking about.
You want us to overrule a few cases.
No, what I'm talking about is, let's suppose we have $100 in bills. What I'm saying is under the statutes, all of these statutes, including Section 3803, the definition of plan under the regulations, MedPay is carved out except where it is permitted to participate as a plan. And under Universal, as I just said, that doesn't happen. When health applies, MedPay does not. I'm saying for that $100, if you have $5, it adds up to copays, deductibles, and out-of-network services, going back to Justice Cordy's question, that is what falls under the MedPay piece of it. It's a question of mutually exclusive portions of bills. This is a meticulous system that the legislature has set up and repeated over the last 50 years in 176A, B, G, I, more recently 176.0 in 2000, and most recently in 2006. It is a legislative carve-out consistently. There is no double payment. It's consistent with what this court went through in Wiggins and Mailhot.
But there's been no double payment here.
Your Honor, if we have a double payment, then we're going to violate all of those statutory schemes.
But where's the double payment here?
They're asking for double payment, Your Honor. If MedPay were to pay,
Yeah.
then there would be a double payment upon what was already covered by health insurance. That's the double payment.
But there's not, okay, but there's not been a double recovery by the plaintiff.
She had
There
to
would
pay
be-
the lien. She had
I'm
to
sorry?
She had to pay the lien.
She had, the lien was recovered. She had a pre-existing, her husband had a pre-existing, or there was pre-existing health care that she had. That was paid. The lien was satisfied because the health carrier paid all those bills. She never paid any bill in terms of what was covered by health. She couldn't have. It would have been illegal.
Yeah, but after Blue Cross paid those bills,
Yes.
it recorded a lien against her personal injury recovery, against her tort recovery. And after the case was resolved, the money from the tort recovery, or some of the money from the tort recovery, was used to satisfy the lien. So she has paid out $32,000 in medical bills, and she's now looking to her MedPay to pay those bills.
The health insurance carrier recovered $32,000 on the tort recovery. But, Your Honor, let me focus the court on this. The word is isolation. If you go to Frost, and you'll see that the Frost decision draws a distinction between what the plaintiff is arguing here and what Your Honor is questioning about, which is really trying to mix apples and oranges, taking this overarching common law equitable question about whether or not somebody is made whole and applying it in a context where it has no application whatsoever. This is a case where we're talking about contract, and under the contract, the medicals, as the motion judge observed and as this court observed in the Frost case, is different. As a contract analysis, the word isolate is right in there in Frost.
So is incurred in this contract.
Yes,
Word incurred.
yes, it is, Your Honor.
So when she pays the lien, she's incurred those costs.
No, incurred under the Green case that's cited in Mailhot that we give you, and that was a legal services contract. This court said, no, that's not what incurred is. Incurred means you have to be personally responsible for it, which she was not. Also, in the Carth case, the same point is made. Incurred means you're legally responsible for that bill, and expense means you pay that bill out of your pocket.
So if Blue Cross Blue Shield had gone bankrupt, who would have paid the bill?
If Blue Cross,
Yeah, who would have paid the plaintiff, Golchin's medical bills?
it may well have been, depending upon indigency and things like that, maybe the state.
Well,
the
forget
question
about
is,
indigency.
If there's no double
If she's
payment,
not indigent, and who pays the bills?
if MedPay could apply there, if there would have been no double payments, then we wouldn't have the problem that we have here. But they were paid by Blue Cross. Your Honor, I also want to underscore the moral hazard problem.
Excuse me, does this all depend upon the interplay with health insurance? Or what do we do? Doesn't MedPay also pay for burial expenses, funeral expenses? Suppose there was burial insurance. You take the same position about that?
The position we're taking only has to do with health insurance, Your
No, I
Honor,
understand it, but what's your construction? I mean, there's no double recovery. Suppose she had burial insurance, and she died, and she had expenses, and then burial insurance paid for it. Does MedPay also pay that?
If they're both indemnity policies, Your Honor, then I'd say Wiggins and Mailhot may well apply to, so they only get single recovery on it.
So it doesn't really implicate so much the health insurance system as a whole.
Where
And
health-
You're talking about really because it seems to me that it's the same principle, no matter whether it's burial insurance or health-related costs.
Because of the specific issue we're here on today, Your Honor, health, where somebody collects on health and then they're trying to double up on MedPay, here are the three things that apply. The common law bar, the four statutes, universal health, 176.0, the coordination of benefits, linking all that together, the section 3803 carve-out. These are all carve-outs of MedPay where health applies. All of these are statutes. They all apply. They reaffirm the common law indemnity bar principle. They're a statutory statement for the last 50 years saying what this court has been doing for the last almost 200 years is absolutely correct and is all the more important in this very specific context that is specifically addressed by the court, by the legislature.
Well, I'm sorry to make you repeat yourself, but what was your answer to Justice Spina when he said this was a primary insurance policy, and you keep saying it's an indemnity policy?
Primary policies, insurance policies are indemnity, some of them are indemnity policies. This is an indemnity policy because it incrementally provides restitution, which is to be contrasted with a life insurance policy or the other cases, the other situations discussed. Again, in the Frost decision, there's cases concerning other types of policies where the benefit that's paid is $10 over 30 days for a given incident, a given injury, set dollar amounts or set packages of medical care that are provided. This is an classic
Is that in the
indemnity
policy? Is that in the MedPay coverage language?
Is what, Your Honor?
This incremental payment?
No, I'm talking about what the cases tell us about and what the authorities tell us about what an indemnity policy is. And this is an indemnity policy. Also, Your Honor, on the moral hazard, there's an incentive built in the plaintiff's position here. Every time the medical payments, a financial incentive, because they would recover dollar for every time they go for another round of physical therapy or chiropractic care or what have you, there's an incentive for them to inflate damages on their third-party claim because dollar for dollar, they will, under their theory, they would get a double payment, a recovery that would go back to them. So if they add, the bills go up on the health side, therefore the expenses go up on the motor vehicle side, the legislative purpose under both statutory schemes is defeated. It's exactly the opposite of what the legislature wants in Chapter 175 on auto and 176 with all that, all the parts of 176 under health insurance. It would be a disaster from a public policy standpoint to allow that to occur. Your Honor, as I see my time is up. Thank you very much.
Thank you.